Hi, everyone. I'm so excited to be back for part two of our series for National Small Business Month, where we're going to discuss protecting your brand and your business and concentrate on trademarks, contracts, and IP essentials for Texas entrepreneurs. I hope that you can find value in the information that we're going to provide. And please feel free at any time that you have them, post any questions that you have, and we'll be happy to address them during this time with you. All right, let's give a couple seconds for others to go ahead and join in, and then we will hop straight into all the information that we have for you today. Trademarks, contracts, and IP essentials, there's so much to discuss. So just know that what we're discussing today is a brief overview. However, if you would like to set up a time where we can kind of dive into how each of these applies to your specific business or your specific idea, then we are happy to do so. You can visit our website at www.theclfirm.com or give us a call at 713-574-2070. All right, without further ado, let's go ahead and jump in. So, what we'll cover today is why brand protection is an actual business asset, why it's important, what it consists of, and how you actually file a trademark, trademark clearance searches, and common pitfalls with those contracts specifically within service agreements, and then those that are non-disclosure agreements and non-competes. And then we'll also talk about digital brand protection and steps that you can take to protect domain names and social media handles, as well as to protect any sort of brand rights you have when it comes to others using domain names and social media handles where they may not be the appropriate owner. All right, so let's get started. Why is brand protection even important, right? The real reason that brand protection is important is because it's an asset of your business. Your brand is an asset of your business. It is what makes money for your business. It's what brings in clientele. People really know a brand. And I usually give people examples of things like Kellogg, right? They are a company, Kellogg Incorporated, that make different types of cereal. Now, when your child or maybe yourself are making your grocery list or you're going through DoorDash to figure out what cereal you want, you typically don't just type in Kellogg's. You'll typically type in something like Frosted Flakes or Special K. Those are brands that are owned by Kellogg's Incorporated, right? So they're the name of the actual product that this company is known for. The same when it goes to passing by, even if you're on the freeway and you just see a big logo off the side, maybe it's a Starbucks logo. It doesn't have to say a full menu of what they offer. You just see that specific logo and you're like, ooh, that's Starbucks. I can get some caffeinated products there, something refreshing to drink, maybe some little snacks to chew on as we're on the road, something like that. And so the reason that brand protection is important is because your brand is what makes your business. It is often your most valuable asset, and that's why you need to protect it and why it's crucial to actually protect your brand. So, 77% of consumers make purchase decisions based on a brand name. They may be more willing to try coffee from the company with the Starbucks logo than mom and pop coffee shop, which is down the street, 2.9 billion plus dollars is spent in annual trademark litigation costs in the US alone. And there is no recourse without a legal registered trademark, meaning that you can't try to seek recovery, for use. It's going to be very difficult if you do try when you don't have an actual registered trademark. So a registered trademark is not just a legal formality, right? It's a business asset that increases your company's value, prevents competitors from copying your brand, and gives you legal standing to fight back. So what does it mean when it says that it is actually increases your company's value? So a trademark is a form of intellectual property. The same way that you can have real property such as land or a vehicle, trademarks are a form of intellectual property. That means that you can own a trademark, you can lease a trademark, and you can sell a trademark. You may be a trademark owner and still lease the rights to another business to be able to use the name for a specific set amount of products or services in a limited way that doesn't necessarily conflict with the way that you use it. Or you could completely sell your trademark rights without selling off your business. So it is its own piece of property, and that is why it is the valuable asset of a business and can increase the value of your business. On shows like Shark Tank, where some of the investors are deciding whether to invest in a business or not, and they're looking at the value of the business, what the assets that the business has, this is something that can help to increase the amount that they are willing to invest or that they think the business is worth, is whether or not the business has a registered trademark. So that is something that is important to consider. So at the Curry Law Firm, we do handle trademark registration, enforcing those rights that a registered trademark can offer you. So sending people a cease and desist letter, or making takedown requests on social media platforms if someone is wrongfully using your trademark. And then general brand protection. So that could also be litigation for you, or any sort of matter with the Trademark Trial and Appeals Board. And because trademarking is done through a federal office, the United States Patent and Trademark Office, we don't just limit our services to Texas, right? We can actually help people from California all the way over to Washington, D.C., because it is a federal area of law. So we can practice this in every state when it pertains to trademark rights and trademark protection with the United States Patent and Trademark Office. Trademark basics: what, why, and how to file. We're going to go into some detail about everything from clearance searches with the USPTO website to actually registration and what each step consists of. So, what a trademark actually protects. A trademark can protect a business name, such as Kellogg's. It can protect a logo or a design. So maybe it's like the special K logo. Another example could be Nike. The swoosh symbol is a logo. And then Nike itself is a business name. McDonald's, the golden arches. You may just see, once again, that logo and you're like, hey, that's McDonald's. That can be protected. The actual business name. Product names such as McFlurry, McDouble, things like that. Taglines or slogans. Nike has "Just Do It." Domain and digital brand names, so you can even protect those. And trade dress. So one of the most popular trade dress items would be Coca-Cola, who has trademarked their signature shape of their Coca-Cola bottle, which we refer to as a Coca-Cola shape. And this is really based off back, when they first came out with like the glass bottle, it has a certain look to it, right? The Coca-Cola shape. Pepsi can't use that same shape on their soda products. When it comes to certain colors, in very rare occasions or rare instances, you can also trademark a color, such as Tiffany & Co. has trademarked the color Tiffany Blue. So those are types of things that you can trademark. The trademark filing process. What does this consist of? So when people are coming to us for trademark services or just to try to find out general information about the trademark process, I like to explain to them that a trademark process is a long and lengthy process, but the benefits that you get from an actual registered trademark are phenomenal, right? They can take you so far. They can help you in protecting the brand that you're building and preventing copycats and infringers from being able to use it, and make sure that the brand that you're building directly relates to the company that you have, and that no other company is profiting or benefiting from the hard work that you're putting in to grow your brand and increase your brand visibility. So we start this process with a clearance search. The clearance search happens with the United States Patent and Trademark Office. They have an option on their website called a trademark search, and it allows you to go ahead and search for other applications or pending applications or registrations for wording that is the same or similar to what you want to trademark. Once we look at what is already out there, we do a deeper search into what are the services or products that name is protected in connection with. Now, during your clearance search, you could find that more than one company or business actually owns trademark protection. for the same name. For example, Delta. Delta is a trademark that is owned by a dental insurance company, right? And it's also a name that's owned by an airlines company. Both companies have been able to successfully trademark the name Delta, but they offer services that are unrelated to one another. Typically speaking, when you're looking to purchase dental insurance, you aren't necessarily at the same time or on the same website looking for airline tickets. You may be looking for it within the same day. However, you wouldn't be confused about who is the true owner of the mark or who are you actually purchasing the services from when it comes to airline services versus as dental insurance. So, as long as the uses of the name are different or in different industries, are different enough as to not confuse consumers about who they're actually purchasing the services or products from, the trademark office could allow more than one person to trademark the same name. When you actually hire an attorney to do a clearance search, typically we're doing a more thorough search. There are specific databases that just attorneys can use to do deeper dives into searches of names as well as into imagery if you're trying to protect the logo, slogans, trade dress, and things of that nature. And we're typically doing those deeper dive searches to really see what your options are going to look like when you do submit your trademark application. It's important to note that if you do submit a trademark application and it's likely to be confused with something that's already registered or something that has a pending application, the USPTO does not give any refunds, right? And attorneys don't give refunds for the work that they've completed and for the services that they're rendering up to that point. So I don't want you to think that, oh, if it's already taken, the trademark office will let me know. They'll just reject the application and they'll issue a refund. No, they don't issue a refund. And that's why it is crucial to make sure that you are doing a thorough clearance search ahead of time or having an attorney perform a clearance search for you to make sure that the name that you want to trademark or the logo or the slogan, whatever it is that you're trying to trademark, is actually something that will have a good chance of getting approved, right? Because if they reject it for a likelihood of confusion, then you're not going to get your money back, right? You're going to have to go back to the drawing board, figure out something else, and submit a brand new application. You can't change that application after it's been submitted with anything substantial, right? Maybe adding an apostrophe in there may not be a substantial change, and they'll allow that. But trying to change significant wording or imagery, they're not going to allow. So that's important to know, and that is why clearance search is so important. Choosing your filing basis. There are two filing bases when it comes to filing a trademark application. That is 1A and 1B. 1A means that you actively use the mark in commerce, meaning you're already advertising or making sales with that specific mark. Or 1B is that it is an intent to use mark. You intend to use it in the near future, but you don't quite have actual proof of how you advertise or make sales with that specific mark at this time. Each has different requirements and timelines for processing when it comes to analyzing the entire trademark process in total. Now, it is important to note that when it comes to the 1A, use in commerce, you actually do have to provide proof of making sales or how you advertise with this specific mark that you're trying to protect. And with the intent to use, it allows you to start the application process and get as far as to step 5, which is the publication period, without having to show any sort of proof of use. So it allows you to put in the application to temporarily put a hold, right, on others being able to get that name approved while you start to gather your evidence to be able to show proof of use. And so some people are like, well, it doesn't just make more sense to wait till I'm already using it? Not necessarily, because trademark office goes off of first to file and first to use. And it's not uncommon for people to file intent to use applications. For example, Beyonce and her mother have a hair care line called Sacred. When they did the initial big Sacred launch and they first came out with the product a couple of years ago, as a little like trademark nerd, I'll call myself, I went and searched the trademark database to see what their trademark actually looked like. And they had an intent to use application that was in, right? They had submitted the application about a year before their launch. It was for Sacred for cosmetic products in class three, but it hadn't been fully registered. But because they knew that they were spending money and putting time into actually having a product launch with this, they went ahead and got their application in and got it all the way up into the point where the USPTO just needed to see proof of how they actually advertised or sold the product. Once they launched their product, then they now had that proof and they could finish out their process of being fully registered. So that's an example of why it's beneficial to go ahead and choose the intent to use application as opposed to waiting until you actually do use the mark in commerce versus, like I said, waiting. So step number 3 is to file the application. We file your application with the USPTO, which will identify the mark that you want to protect, identify the specific goods and services that the protection will apply to, and the correct international classes. So just to go a little bit more in depth about goods and services and classes, I talked at the beginning of this slide about the Delta example where two businesses could have the same name trademark by offering two different types of services. That's why it's important in your application that you fully outline all of the services or products that you intend to offer as it relates to this specific name, and what people will recognize that brand for. Like if they were to see that logo or hear that business name, what do you want their mind to directly connect to as a specific service that is offered or the specific product that is offered under that brand? And so the USPTO has international classes, which is short for classifications, that actually have numbers related to them that represent the most general types of services or products that people offer. For example, class 3 covers cosmetic products such as hair care products or makeup products, right? Some type of skincare products. That's class 3. Class 25, on the other hand, covers clothing, footwear, headwear, things of that nature. Whereas class 41 covers education and entertainment. So any sort of use for vlogging with a V, blogging with a B. So that could be Twitter, that could be writing a book, that could be used on Instagram or YouTube for vlogging purposes, things of that nature. And that's under class 41. So each set of services or products that you offer has a number of a class that it relates to. And so it's important that your application adequately reflects the correct class numbers and the exact amount of services or products that you're going to offer and want protection under the USPTO for. And so once you have that application in, right, you can't go back to the application and say, okay, now I think I also want to add in like shirts and I also want to sell keychains. No, you will have to file an entirely new trademark application. So it's important that when you do file the application, you have all that information in one place so that you can make sure that your application adequately reflects the type of protection that you need your trademark to offer. Step 4, USPTO examination. So at that point, an examining attorney reviews your application. That process typically is about a 3 to 4 month period. It used to be 3 to 4 months after filing, but right now the trademark office is on a backlog. So usually an examining attorney is assigned to your application about 8 to 10 months after you submit the application. So if you submit the application in January, you should expect it to be reviewed somewhere around October or September of that year. The USPTO examination would occur. And if there's any questions about your application, they'll issue what's called an office action letter asking you to clarify any questions they have about your application or to outline any sort of discrepancies they find, such as likely to be confused with another pending application or registered trademark, or if the wording merely describes the services you're going to offer. Like you are trying to trademark the wording hair salon because you own a hair salon, right? Merely describes the services you offer. They would outline that in an office action. At that point, you have the opportunity to respond to any office action letters to try to clarify or provide legal arguments about why you believe there should not be a likelihood of confusion or why you believe there should not be a merely descriptiveness found on your application. And the trademark office gives you 3 months from the date that they issue their office action with those questions or concerns to when you actually have to submit the response. So sometimes that back and forth period can add some more time because you're trying to prove your legal case there. Other times there may not be any questions and your application just gets approved for the next step, which is step 5, publication for opposition. At this stage, your applications are published in the official Trademark Gazette, and it's an opportunity for any third party to oppose your application if they feel that they have a higher claim to that specific brand name or that specific mark. And so some people are like, are you serious? I paid all this money. We've waited all this time, gone back and forth with the trademark office about office action letters just for some random Joe on the street to oppose my application. And I always say, well, yes. However, oppositions are very rare. Number one, someone has to be actively searching the trademark database to see what applications are out there. Number two, they have to prove that they had a higher claim and title to the name, meaning that they began using the name before you did and actually have proof of how they were advertising or making sales with that name and have been consistently doing so since their original use. And number three, they would have to prove that they actually think that consumers will be confused as to who is the true owner of the specific brand, right? And so to file an opposition against an application, it's not free. There is about a $600 to $800 fee that you're paying just to submit the opposition. And then most people actually do hire an attorney to represent them during that process because it moves to a separate division within the trademark office called the Trademark Trial and Appeals Board. And so it becomes a pretty expensive process for both parties, the person who is submitting the petition for the opposition, and then the person whose application is actually getting opposed. So it can happen, but it isn't very common or very frequent, I'll say. And then once you have passed the publication period and nobody has opposed your application, or if you were able to combat any sort of opposition that was posed against your application, you become a registered trademark holder. So in total, the process usually takes about 8 to 12 months to become fully registered if there's not any sort of major issues with your application. If you run into any issues such as someone opposes your application or there's more office action back and forth communication than anticipated, then that 8 to 12 month period could increase. You do have to renew at the 5 and 6 year mark of using the trademark. So if you filed your trademark in 2020, you should probably be getting a notice this year, now in 2026, about the fact that you need to go ahead and renew your trademark protection because you need to do it about the 5 or 6 year mark. You're also going to have to do it again at the 10-year mark to make sure that you're still using the trademark. Trademark office is very adamant about protecting the trademark rights of those that are using their marks and protecting the brand. However, they don't want to hold that open if you're no longer using it, right? A lot of people form businesses during COVID that are no longer active and are now defunct. And so they may not be renewing their trademark, right? As they're not actively using it. And so it leaves opportunity for someone else who is going to actively use the brand right now to go ahead and swoop in and go ahead and register that mark. And I will say that that is also a reason that you should have an attorney do the clearance search for you, because I've done consults with people who are like, yeah, I already did a search. I know I can't use this name because someone has a trademark, and I go search and I see that their trademark is set to expire and they have not filed their renewal. And I'll say, maybe you want to call us back in about a month or two and see if that trademark holder has filed their renewal by the deadline. And if they haven't filed it by the deadline, they're going to lose their mark. It's going to get canceled. And that leaves room for you to come in and actually be successful in trademarking the mark. And they're like, wow, really? That's how that works? Yeah. If you don't renew your trademark, somebody else can file to register that trademark for their specific brand. Common pitfalls. So here are 5 trademark mistakes that destroy brands. Number 1, filing without a clearance search. People who don't hire an attorney, they'll just file the application themselves. They skip the search, and it leads to rejection or oppositions, or worse, causes cease and desist after you've built brand recognition. And this happens. I can't even tell you the amount of times that I've gotten calls from people trying to figure out what they can do now because their trademark application got rejected and they've received a cease and desist letter. So you really need to make sure you meet with an attorney before you file the application and before you really start using any sort of logo, slogan, or brand wording to actually advertise or market your products or services and put money and sweat equity into that, because you want to make sure it's something you can use long term. Otherwise, it's a waste of time and money. Number two, using a descriptive mark, names that simply describe your goods or services, such as Best Texas Pizza. I gave the example of trying to trademark the wording hair salon for a hair salon, right? These are nearly impossible to register and protect because they're wording that is commonly used in your industry. A trademark is meant to protect wording that is unique, wording that when people see it or hear it, they can directly relate to the actual service or products you offer. But generic wording such as Best Texas Pizza or Houston Hair Salon don't exactly make people think about a specific brand or a specific company that offers that service or that product. And that's what we call merely descriptive. Number three, choosing the wrong class. Remember, I said you need to make sure that for the specific services or goods you offer, you have the right class number that relates to that. And so choosing the wrong one and making the trademark protection for something else that you didn't intend to actually offer that service or that product can mess up your application, because you have to show proof of how you actually advertise or sell that specific product or service. And if you've selected the wrong class number, you're not going to be able to show proof, right? If my business is all about offering legal services, but I accidentally clicked the class number for beauty services or barbershop services, that's not any use. I can't show the USPTO that I use my specific mark for those services because I don't offer those, right? So trademark protection only applies to the specific classes you register. And if there's a wrong class that you accidentally connect your application to, then it's unprotected in your core market, right? And so you're missing areas of protection when you really need to make sure that the appropriate classes are used to really protect your mark as it applies to all of the products and services that you offer or intend to offer in the near future. And that's why it's also important to meet with an attorney so we can try to help you brainstorm all of the type of protection that your application should really outline. And the other one is failing to enforce your mark. So that means that you already have the registered trademark, but you're not enforcing it and you're not stopping others who are infringing on your mark and using it in unauthorized ways. That can actually weaken your rights over time. Part of the rules of having a trademark is that you actually have to enforce your trademark rights. Contracts. All right. So the bread and butter of a lot of business is contracts. In the last webinar, when we talked about structuring your business, we talked about the fact that the structure of a business is meant to separate the individual liability that anyone has from the liability that their business has, right? But the way to actually protect your business is with contracts, right? And so that is why they are so important. They are the backbone of every business relationship. If it's not in writing, just assume it's not enforceable. So every business relationship needs a contract, and here are some common types of contracts. Client service agreements or service agreements. These type of contracts define the scope, deliverables, payment terms, and what happens when either party doesn't perform. Vendor and supplier contracts, they lock in pricing, delivery timelines, quality standards, and remedies for breach. Independent contractor agreements. This is a type of classification for workers, and you need to make sure it's the correct one for that specific type of worker. And it defines work product ownership and product confidentiality information, as well as taxation expectations for that specific individual and benefits, right? Independent contractors, They don't get the same benefits that an employee gets, and they're not taxed the same way that an employee does, and that should be outlined in the independent contractor agreement. Then we have partnership and joint venture agreements. The JV is short for joint venture agreements, and this define roles, capital contributions, profit splits, and exit procedures for every partnership. So maybe you're going into business with someone, your business is going to be working with their business to put on a certain event or to offer specific services to people. And you want to have an agreement in place that can outline what each party is responsible for, how income and profit is going to be split, how taxation should occur with that, and so forth. Those would be useful there. Operating agreements, they govern your LLC. So it will outline the ownership percentages for the LLC, the authority, and dispute resolution all in one. Every single LLC needs to have an operating agreement. Some states actually require that your LLC has an operating agreement. The state of Texas does not. However, it is still a crucial document that you need with your business. It's not anything that's filed. It's something that you actually keep on hand in your business and have prepared to outline exactly what the ownership structure is, the duties of the owners, how the business is going to be taxed, the type of liability protection that's offered to the owners, and so forth. Settlement and release agreements. These properly close out disputes with enforceable releases that protect your business from future claims. So here's what every strong contract should include. Parties and definition, right? Who are the parties of this contract, right? Is it an individual and a business? Is it two individuals? Is it two businesses? You should clearly identify who is bound and define key terms to prevent interpretation disputes. Scope of work services. So you need to describe what is being delivered. A vague scope of services can lead to non-payment and can lead to business disputes, right? So your scope of services is something that thoroughly outlines the exact services that are being exchanged during that time period, or your scope of work. Sometimes in a contractor where you're hiring someone to perform contract services, there's a scope of work for that, the exact renovation services that are needed or building services that are needed. Payment terms and late fees. Set the rates. Be very clear about what exactly this transaction should cost so that people can't try to change the rates down the line. What are the due dates for these payments? How is payment received? Is it by check? Is it by wire? Is it in person, right? Is it electronic transaction? Are there any late fees? What are those percentages, or what are the set amounts? And what triggers the right to stop services? If someone refuses to pay, does that trigger the right to stop services, or do you have to continue offering those services? So those things should be outlined clearly. Term and termination rights. Define how long the contract lasts. What are the notice requirements if there's any sort of termination of the contract? How do you have to notify the other party? Is it in writing via certified mail to a specific address? Do you have to send it to a specific email address? Do you have to make sure that a specific individual is noted? All of those are usually outlined in a contract. And what are grounds for early termination? I can't tell you the amount of contracts we looked at and they don't have any sort of section for early termination, or people come to us and they're trying to figure out how to get out of a contract, but the contract doesn't address early termination, right? So now we're trying to figure out, okay, what are their grounds for getting out of this contract without breaching the contract? Intellectual property ownership, right? You need to specify who owns the deliverables, the work product, and any intellectual property created during the engagement. Dispute resolution clause, right? Can you mandate mediation or arbitration before litigation? You can decide that in your contract. You can specify the state as the governing jurisdiction, any sort of county within the state. You can state that, hey, if any sort of resolution needs to occur or any sort of lawsuit is filed, it needs to be filed in Dallas County, or it needs to be filed in Travis County or Tarrant County. You can specify that in the contract. And then contractually shift attorney's fees to the losing party. This dramatically improves collection leverage. So you need to make sure that your contract addresses who should be awarded legal fees based on the way that the decision is made to handle the dispute. That should be included in your contract. Who can recover attorney's fees? NDAs, that's short for non-disclosure agreement. And then we have non-compete agreements and confidentiality. So these types of agreements are meant to protect your secrets, your clients, and your competitive edge. So non-disclosure agreements versus non-compete agreements and non-solicitation agreements. What's the difference? So an NDA is used before pitching investors or partners. So you would have someone sign it before you're sharing proprietary information or processes. It protects customer lists and pricing strategies with people who are coming into contact with this confidential information. It should cover mutual and one-way obligations. So you can have a mutual non-disclosure agreement or you could have a one-way non-disclosure agreement. A mutual says we're protecting each other's, right? I'm going to see information that's confidential to you. You're going to see information that's confidential to me, and we are not obligated to share this with anybody, nor do we have the right to share any sort of information that's not known to the general public. Or one-way obligation says, hey, you're going to be coming into contact with a lot of confidential information of my specific business. You do not have the right to share this, right? You can't share any of the recipes, any of the trade secrets, or anything like that. And it also includes remedies for breach. So if somebody does share the confidential information that they were bound under the non-disclosure agreement not to share, then you have the right to sue them for that and get damages for that. So with the whole Diddy case, right, there was some sort of settlement agreement that was signed where Cassie got some payout. So she stopped her process of suing Diddy personally. But for that, she had to sign a non-disclosure agreement. So she couldn't disclose what that, total amount was if it already wasn't public record or wasn't known broadly to the public. And that also happens when people are getting large settlements from corporations or things like that, is that they may have to sign a non-disclosure agreement as part of that. They can't disclose, the payout that they're getting or what the settlement was for. Now, non-competes and non-solicitation, they are meant to protect something different. And it's important to note that when it comes to non-compete agreements, Texas will enforce them with certain conditions. So they tried to eliminate them completely, but then it went to what we believe the Texas Supreme Court. And so it came back that you can enforce them with certain conditions. So it must be ancillary, meaning it can't be too harsh on a person. It can't prevent a person from doing too many actions or have too many restrictions. With the restrictions, they must be reasonable in time, geography, and scope. So maybe a person stops working for you or a person is working for you, maybe as a massage therapist, and you tell them they cannot work as a massage therapist for any of the time that they're working for you, right? Within a 5 or 10 mile radius of the business that you have, and they can't offer those specific services. They may be able to work at a different business or offer different services within that same area while they still work for you. But while they work for you, they can't offer massage therapy services, within a 5 or 10 mile radius of where your business is located. That's something that would be considered a reasonable restriction. Non-solicitation prevents poaching clients and staff. Maybe you have a daycare business, you fire someone, and they start trying to take families and children and staff members with them as they're leaving. Why don't you come work for me over here? Why don't you come try out my new daycare over here? Your child may like it, or you may make more money with me or have a better work environment. Non-solicitation clauses in a contract prevent people from poaching your clients and staff. It must be signed at hire, not after employment begins. So it has to be signed when the person starts working for you so that they have the opportunity to decide if they want to agree to that or not. We actually work to enforce violations in Texas court. So if there was a proper non-compete agreement signed or a proper non-solicitation agreement signed, or those clauses were in a contract that you had an employee or independent contractor sign and somebody has breached that, then we can actually go ahead and send a demand letter or file a lawsuit on your behalf. Digital brand protection, domains, social media, and protecting your brand online. So protecting your brand in the digital world is super important these days because a lot of advertising happens through social media and through the digital world. So cyber squatting, social media impersonation, and unauthorized use of your brand online are real and growing threats to businesses, not just in Texas, but across the globe. So here's some steps you can take. Number one, you can register your domain. You can secure all variations of your domain name before competitors or squatters do by purchasing them. So host sites such as GoDaddy or Wix, you can actually purchase all variations of your domain name through them. Claim your social media handles. Register your brand name on every major platform, even ones you don't use yet, so that no one else can create pages using the social media handle for your specific trademark or your specific business name. Federal trademark and online leverage. With a registered trademark, you can file complaints to reclaim cyber squatted domains. So this can happen a lot where someone doesn't necessarily purchase the domain name immediately. Your business and brand starts to grow and starts to gain awareness. Someone could go buy your domain name for $10 and then try to sell it back to you for $3,000. If you have a registered trademark, then you can file a complaint with the UDRP to reclaim your cyber squatted domain. Monitor openly for infringements, right? Set up Google alerts, trademark watch services, and periodic social media audits to go ahead and monitor if someone is using your specific trademark or your business name to offer the same or similar services or products. Platform takedown procedures. So companies like Meta, which houses Instagram and Facebook, TikTok, YouTube, and others have intellectual property enforcement processes where you can actually submit trademark infringement claims or copyright infringement claims, and they have a takedown process. But you have to, for it to be trademark infringement that you're claiming, you have to have a registered trademark with the United States Patent and Trademark Office. Can't be a pending application. It has to be a registered trademark certificate. You can also do this for copyrighted materials such as videos. Maybe you created a video, someone else is reposting it, and they're getting paid for each view. You can submit a copyright takedown request with any of these social media platforms for any sort of infringing use of your creative piece of work. Website terms and privacy policy. This is a growing matter where you can actually get sued if you do not actually have a privacy policy listed on your website. It's federal law that you are required to have the privacy policy on your website if you collect data, run a store, or engage customers online. And it must be legally accurate, right? I recently saw a video where a person was telling a story of how they got served with a lawsuit because they did not have a privacy policy on their website. And that's required by federal law. So how can the Cray Law Firm help you protect your brand and your business? We do offer comprehensive intellectual property and contract services under one roof. We don't have to refer you to anyone else. You don't have to run around. We can help you with trademarks. We can help you with copyrights. We can help you with contracts. And we can also help you with enforcing those rights once you have them. So we can do trademark clearance searches. These are comprehensive federal and state searches before you invest in a brand name or a mark. We can file your USPTO application, monitor it, and respond to office actions through the registration process with the USPTO. We do custom contract drafting. So we can also create service agreements, vendor contracts, operating agreements, and more. We can also handle non-disclosure agreement and non-compete agreement drafting and enforcement, right? So if it's already signed, we can enforce the rights that are listed in the agreement. But if you need it to be drafted, we can also draft it as well. In addition to trademark filing and trademark searches, we also do trademark enforcement. We can file lawsuits against infringers. We can file takedown requests through social media platforms, and we can send cease and desist letters to parties that are infringing on your trademark rights. And then digital brand protection. We can provide the terms of service that can go on a website, privacy policies that need to go on your website, and then also submit the claims for any sort of infringers for your digital brands, such as like someone using your domain name or something like that. So we'll now open the floor up for any questions that you may have. We'll be happy to answer those. And so also we have listed on the screen some commonly asked questions. Can I trademark my business name if it's already registered as an LLC? Absolutely. Your LLC is an actual structure of your business entity. It does not provide brand protection. A trademark provides brand protection. So those are two different types of protections and rights. The LLC is meant to separate your personal and your business liability and assets, while a trademark is meant to provide brand protection. An LLC is filed with your state versus the trademark that we've been talking about is filed federally with the United States Patent and Trademark Office. What type of contract do I need for my specific business model? Well, you can set up a call with us and we can go through different types of contracts that could be useful for you to have. Maybe you have an LLC, but you have never formed your operating agreement. Maybe you offer services, but don't have a proper service agreement in place between your business and your clientele. Maybe you're getting ready to go into a specific partnership or joint venture with another party and you need a partnership agreement or a joint venture agreement. Maybe you're getting ready to hire individuals and you need to figure out if they need an independent contractor agreement or an employment agreement, and if those agreements should include language for non-disclosure, for non-compete, and for non-solicitation. We can help with all of those. But we would need to talk with you to kind of analyze what situation you're in, do a legal audit of your business, and determine the types of contracts that would be helpful. And if you already have contracts, but maybe you've run into a certain issue with a client or a vendor, and you realize that your contract hasn't properly protected you in all the areas that you need, we can amend those contracts to make sure that they more fully protect the type of services and products that you offer and the type of liability that your business can be exposed to. What happens if someone is already using my brand online? Well, it depends. Maybe they have already submitted a trademark application. Maybe they already have a registered mark, or maybe they don't, and it's an opportunity for you to swoop in and be able to claim that brand protection and file with the trademark office before they do. How long does the trademark process take and what does it cost? The trademark process takes usually anywhere from about 10 to 12 months from the time we submit the trademark application until we have a fully registered mark. And what does it cost? We add on legal services fees to the application fee. The application fee can change at any time. It is in accordance with what is on the USPTO website at that time. So you can always search USPTO trademark fee schedule and it'll tell you what the application cost is at that time. And then for our specific legal services, you can call into our office and we can talk about the specific help you need. Maybe you just want the trademark search. Maybe you need us to file your renewal because you already have a registered trademark. Maybe you need us to respond to an office action. You started the application yourself, but now you've been issued an office action letter and you need us to respond to it on your behalf. All those fees will vary based on the type of service you need. So you can contact our office for that. All right. Well, thank you all so much for joining us for part 2 of this month's webinar series. We look forward to being able to help you for any of the needs that you have. Our next series, or not next series, but the next webinar within this series, we'll be talking about scaling without the risk. So hiring individuals, partnerships, and compliance, and what that deals with on a legal standpoint. If you have any questions or concerns, feel free to visit our website at www.theclfirm.com or give us a call at 713-574-2070. Thanks so much for joining, and we look forward to seeing you next time.